The next case to come before the court is State of Ohio v. Garrett, Greenstreet. You will have up to 15 minutes to present your argument. Please stay behind the podium and keep your voice up. Our argument is being recorded, so please don't refer to any children, minors, or victims during your argument by name. You can use initials or terms that are general if that applies to your case. We have read your brief, and you're ready to proceed when you are.
Very well. Good morning. May it please the court. This is Paul Meyer on behalf of Garrett Greenstreet, who is the appellant in the case. And I can speak probably about 200 words a minute with Gus up to about 300, so I'm going to get going here. This case concerns a violent altercation between my client and his roommate. Both adult males. Mr. Greenstreet had never been arrested for a violent act, and that's in the transcript of proceedings. The victim, CP, we'll call him CP, he does have a prior conviction for felonious assault. Now, I did not try this case, so I have to go by the transcript of proceedings that was recorded at the trial. But this is a clear case of self-defense and the application of revised code 2901.05, which only became effective in April of 2021, brand new presentation of the burden of proof for self-defense cases. And that's what we have here, a clear case of self-defense. Our contention is the Rule 29 motion should have been granted. And I'm just going to read a little bit from the argument that the trial counsel made. He says, the new law specifically states that a person is allowed to act in self-defense if there's evidence presented that tends to support the accused person used the force in self-defense. The prosecution must prove beyond a reasonable doubt that the accused person did not use force in self-defense. And to prove self-defense, all we need to do is show the person is not the aggressor. Now, we had in this case, it's our contention that there was one assault that occurred on this date. One assault on Mr. Garrett by CP. The assault took place in 4 rounds, similar to a boxing match. Unfortunately, we don't have a bell that stops and ends the rounds. We have an assault that started inside the house. There's no doubt about it. Mr. Garrett Greenstreet is struck by numerous blows inside the house. So let's start with this. The state of Ohio concedes in the case that on page 541 that CP started the physical altercation. Okay, he started this fight. They also concede that on page 550 that he is no choir boy, quote unquote. That's true. He has a prior conviction. He starts this fight, punching inside the house. My client flees. He goes out on the porch outside the house. This is his house. He leaves. He gets assaulted outside. Neighbors are watching. He's put on the ground and beaten. He flees back inside the house, locks the doors, and calls 911. Now, when you call 911, you have an emergency. That's the first thing the dispatcher asks. What is your emergency? He tells the dispatcher what's going on. He's getting beaten up. Okay? So what does CP do? He comes over and he starts kicking in the door, starts pounding away. My client is concerned. He's inside the house. He's already been beaten up inside, already been beaten up outside. Now the guy's trying to get back in. He says he doesn't feel safe inside the house on page 518. He didn't want to stay in the house. He was scared. He thought he wanted to keep moving since CP was kicking in the door. So he leaves the house. And they encounter each other outside on the street. And at that point, a knife is present. The two of them grapple over the knife. Both of them are cut. Both of them go to the hospital. When the officers finally arrive, I think Officer Clark testified that he said that what my client said that he was defending himself, that he said that he had been stabbed by CP. The officer saw the wounds. Detective Mazai was also there on page, the transcript of proceeding, page 429. My client tells him that CP had this knife, they were fighting outside, and this...
Other than your client, did anyone else see CP have a knife?
Did anyone else see him?
Was there any testimony other than from your client that CP had a knife?
I don't believe so. I think it was unclear exactly what happened. CP did testify, and I think he says on page 241 that my client approached him and they were fighting outside, and that's when the knife came in. On page 266, he punched my client and got stabbed. This is outside the house in round 4. Okay? So we have a lot of testimony about what happened in this altercation. The state at the trial made a big deal about, like, oh, this fight was over. It was all over. You can't use self-defense when a fight ends. I can't come after you tomorrow because of something happened today. Okay? But this wasn't like this. This was one battle inside the house, outside the house, back inside the house, back outside the house. These two guys were going at it.
That consistent with the testimony of the neighbor woman whose name I won't use and the friend who was there as well, that indicated the fight was stopped and then he went back into the house?
I believe that, well, the one guy inside, the friend of CP's, was taking a video of the fight. You know, this is great. The neighbor lady, whose name I won't use, she knows both of these people, and she said that CP started the fight. She described him beating my client in the yard, and so on.
And then she told them to stop.
She did, and my
at
client...
that point, they stopped and your client went back in the home. Is that a fair view of the evidence before the court?
Judge Stevenson, it wasn't like she said, okay, stop, fellas, and my client quietly went back inside the house. This fight was going on. My client was on the ground getting beaten. She's yelling, stop, stop, or whatever she testified to. My client gets back in the house, not calmly, and, he runs inside and locks the doors and calls 911. He's got an emergency. He's getting beaten up in this assault started by CP. So, the long and short of it is, this is not a fight that ended, and another fight that began, and another fight that ended, and so on. This is one continuous assault started by the victim in the case, CP. My client had a right to be in the house. He did not have a duty to retreat from his own house. He did flee. He did get back inside. He fled again. He was scared. He testified about this. And he is sitting in prison today because of this felonious assault conviction.
Counsel, what about the fact that the witnesses had testified that they heard your client, the defendant, coming out of the house screaming, I'm going to kill him with a knife?
Well, I saw that in the transcript, and I can only say that under the circumstances, he felt his life was in danger. He was being pursued by CP inside the house, outside the house, back inside. He was running, trying to defend himself. And,
But they said he sought out CP.
Pardon?
They said he sought out CP and found him and then just began knifing him.
Well, the way I read it, Your Honor, was that the two of them got into it. My client testified that CP stabbed him first. That's on page 498. Also on page 494, it says, the transcript indicates that CP followed him outside and the fight was continuing and so on. So, he says
was there any testimony CP had a knife?
pardon me?
Was there any testimony that CP had a knife?
Apparently my client got stabbed somehow or another.
I'm sorry, not CP, the defendant, I apologize.
Yeah.
Is there any testimony that the defendant had a knife?
I think somebody, I don't know which witness, said that he had something in his hand.
That's what I'm saying. I'm getting them confused again.
My client's testimony was, he picked up a knife that CP dropped. That's on page 508. He says he testified he says he picked up a knife which the other guy dropped. He says he was running for his life. He also says on page 517, he knows that this CP guy doesn't stop. He doesn't feel safe in the house. He already called 911, he's fleeing, he gets back into it with CP. Again, CP is not a choir boy. He started this fight, he has a prior conviction. He was getting the best of my client inside and outside, and my client is sitting in prison today. We believe that Rule 29 motion should be granted. And,
Well, counsel, you would agree that the law does provide that even though someone else may start out as the initial aggressor, that can change. You know, just because you're the initial aggressor doesn't mean you stay the.
True. If you retreat, if you withdraw from the fight, no problem. CP did not withdraw from this fight. He was inside, he was outside, he was kicking in the door. I believe he was there, he was in the immediate area the entire sequence.
Counsel, just to clarify, I know you've sort of been through this with the inside, outside.
Yeah.
So after he called 911,
Yes.
just tell me what happened with the fight after 911 was called.
Okay, my client's testimony is that because the guy is kicking in the door, he's afraid.
He went back out?
He did not feel safe. He did not feel safe inside the house. He felt that he had to flee. He had to flee. And when he did go outside, the two of them got into it again. The CP punching him. My client says he stabbed him first with the knife on the hand, dropped the knife. My client grabbed the knife. The fight continued. Police came. The first thing my client said to the police was, "This is self-defense." Okay? An excited utterance, if you will.
How, Mr. Meyer, moving to the standard involved here in the question of Rule 29.
Yes.
Based upon State v. Messenger that has now said we review self-defense on a manifest weight standard.
Yes.
How does Rule 29 apply to that?
Well, you know, I read the Messenger case several times, and I'm sure the court is familiar with that case. It's a little unclear in my opinion. I think manifest weight is different than sufficiency. I feel like the argument we're making about Rule 29 is that it should be granted based on the lack of, I think the lack of manifest weight. It was against the manifest weight of the evidence, the conviction is. I think, you know, the judge could have overruled it, or could have granted it, should have granted it. And we felt, our conclusion is it's an exceptional case with compelling evidence of self-defense.
Well, does Rule 29 apply to just the elements of the crime the state has to prove? In that regard, and not an affirmative defense?
All right, so under the new law, the burden of proof is on the state of Ohio.
That to prove beyond a reasonable
Beyond a
doubt.
reasonable doubt, a very high standard. And we feel the transcript is replete with.
But the burden of production is first on the defendant to produce the self-defense evidence.
Yes.
And how does that affect Rule 29, I guess, is my question. All right, is Rule 29 only for things the state has a burden to produce beyond a reasonable doubt?
No, I would say Rule 29 would take into account all the evidence that had been presented when the motion was made. The motion was made primarily the conclusion of the state's case.
Did State v. Messenger involve a Rule 29 motion? Do you recall? State v. Messenger?
I don't. Anything else?
Any other questions?
No.
Okay, hearing none, we thank you very much for your presentation. The court will take the matter under advisement and issue a decision in due course. The clerk, of course, will mail a copy of that decision to you on the day that it is released, and the Supreme Court of Ohio will also post it on its website. Thank you again.
Thank you very much. Have a great day.